credibility. And so again, from 1992 forward, it has not been funded. It doesn't have a funding mechanism. So when you have these cases and you ask someone to be able to review these records so that the defendant is able to get all the exculpatory evidence they need, but the child is protected from information that should not be made public, then you have to use attorneys to do that. To my right is an attorney from my area who's now one of your representatives, and she's done this on several occasions free, because it's just so frustrating to try to figure out the mechanism to fund to get this done. The problem, of course, is you can only go to the well so many times. At some point, your attorneys are going, I've got my practice, because some of those CFC records, if you've ever been involved with them, although they may be duplicative, sometimes they're 500 to 700 pages, and you need to go through those so that you're aware of the child's history. And so to the extent that we use them to protect these children when they have to testify in front of juries about information that in and of itself by the act is embarrassing and overwhelming and criminal, when someone then wants to use other information that is not relevant to harm them on the stand, it's really important that they have these legal representatives. And again, sometimes it's been funded, sometimes it's not. And this funding is absolutely staggeringly needed, especially
Motion on the bill.
Forward.
There's a motion and a second, and I know we have a judge on Zoom, so he may like to make a few comments or not. I know you've been patiently waiting, so if you'd like to.
Thank you, Chairman. Thank you, Mr. Chairman. Thank you, Madam Vice Chair. All I want to add is this was a bill that Representative Nemus presented a version of last year, which was a non-budget year, and we were asked to come back this year. The main difference in section 1 and 2 that the committee substitute addresses was that in the interim, there was a case out of the published case out of the Court of Appeals, Hamilton versus Milbury, which justified the need to change those first two sentences that Representative Dietz had mentioned.
Thank you. And I was going to say I had a case recently where a GAL was appointed in an IPO case for a child, and that GAL wasn't paid. So I completely agree with what you're trying to do here, Representative Dietz. Thank you for the testimony. So we have a motion and a second. Representative Flannery is recognized for comment or question.
Thank you. One question on the payment. Is it $500 like a dependency neglect and use case, or is it at the court's discretion?
At this point, it's at the court's discretion, because it's a little bit different, because you never know exactly what you're going to get in terms of a particular case. I don't appoint them in all cases because the Commonwealth Attorney is doing a great job. But when you have those volumes of CFC records, it's almost impossible not to have someone who reviews them. So I don't have a problem with the cap. I don't know what that would be now, because I haven't, the last person I used, I think, was Representative Dietz, and I know she spent hours and hours and days working on it. So it's pretty extensive when you're representing them and protecting them from these questions.
So I guess it would be somewhat similar to like a friend of the court situation where the judge could make a determination on how much.
Correct. And sometimes they come to court with them. It depends. If very young children, sometimes the guardian ad litem as a legal representative will come through and actually object to some questions. But generally speaking, it's that pre-preparation, which is viewed in the 26A 140.
Thank you.
The answer is different, I believe, with the IPO, EPO part of it. It is treated as DNA, as a DNA case. So it would be a cap of $500.
So would Mr. Secretary please call the roll?
Representative Banta.
Yes.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Important, worthy, good work. Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Down. Representative Flannery.
Yes.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
Yes.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Children deserve the best that we have to offer. Yes.
Representative Wilson.
Yes.
Chair Elliott.
Aye.
Thank you.
With 18 yes votes and 0 no votes and 0 pass votes, House Bill 436 is amended by the committee substitute is passed and will be reported with favorable expression. So congratulations. Thank you.
Thank
Thank you very
Thank you so much.
Today. The next item that we will hear is House Bill 258, an act relating to the torture of a dog or cat. Representative Susan Witten with her special guests.
Two special guests.
So well behaved.
Give him a little bit of time.
Give you some time.
Good morning. Thank you, Chairman Elliott and committee members for this opportunity. My name is Susan Tyler Witten. I'm state representative for District 31 in Jefferson County. And I'll let Jeff introduce himself.
Hello. Hello, my name is Jeff Calloway. I am Ethan's papa and very honored to be here. Thank you.
I believe there's a substitute.
Yes,
Is that correct?
there is.
Is there a motion?
Second.
There's a motion and a second. All those in favor? Aye.
right.
Aye. Those opposed, no. And the committee substitute is adopted. You may
Thank-
proceed.
Thank you, Mr. Chairman. The committee sub simply changes the order of the definitions in section 1. So we are here today because Kentucky needs to address the issue of torture pertaining to dogs and cats for the sake of all good pet owners and their pets. To give some history about this issue, 16 years ago, Senator Tom Buford saw the need to extrapolate cases of torture of dogs and cats from the animal cruelty statute. Torture is now classified as a Class D felony, albeit for subsequent offenses. It was called Romeo's Law, named after a local puppy that had been torturously beaten. Through this law, it was acknowledged that misdemeanors sometimes just don't fit certain extreme crimes of inflicting pain when they are intentional. And this was a good start, and House Bill 258 intends to build on and improve what was done 16 years ago. So some of the problems with the existing statute, and I'll go through those really quickly. The existing statute lacks any and all clear definitions of torture and serious physical injury or infirmity. It does not mention restraints, one of the key conditions under which a pet can be tortured when it cannot escape. And the exemptions in this statute are incomplete and do not cover instances that may be considered an infringement on owners' rights. And it refers to torture as a misdemeanor and only allows for felony charges on a second act. We also need to ensure any concerns for good pet owners' rights or those of our hunters and farmers, good and respectable breeders and trainers, make sure that they were addressed. So at the suggestion of Craig Curry of Protect the Harvest and working with Dee Robinson, the language was rewritten and expanded to address a number of owners' rights that they had been challenged in the past, and it was presented to the Kentucky Farm Bureau and the houndsmen and received no further concerns. It was important that we listen to these groups' concerns to get these issues properly resolved and addressed, and that's what we did in the language in House Bill 258. And now I'll briefly explain some of the changes that are in this bill. Number one, the specific definition of torture includes the two types of torture, physical injury and physical infirmity, and examples of these types are included in the bill. Number two, the definition of restraint stresses that the cat or dog has been intentionally made incapable of physically escaping and saving itself from this specific imposed torture. Examples of these restraints are also included in the bill, but all clarify this is intentional restraint and that the animal is allowed to suffer from cases of physical torture or infirmity. Without the condition of restraint, some cases might be considered accidental. Locked up in a cage isn't enough to be charged with torture, but being intentionally starved, causing serious injury or death while being locked up and unable to escape does fit the definition. Number 3, wanton disregard has been added because these offenders know what the consequences of their actions are going to be, and they just display a lack of care. Number 4, we also included the exception of breed-specific alterations done by a veterinarian, including cropping of ears and docking of tails. And number 5, all existing exemptions are still in place as long as there is no intent or disregard that causes, increases, or prolongs the pain or suffering of a dog or cat. Also retained in this is the right to defend yourself or another person against an aggressive or diseased dog or cat, or in defense of a domestic animal from an aggressive or diseased dog or cat. And in addition to these revisions, we added that each act of torture of a dog or cat may constitute a separate offense, that torture of a dog or cat is a first offense, Class D felony, and that humane euthanasia of a cat or dog that has been seized as a victim of torture upon recommendation of a veterinarian is permissible. It is also important to note the documented correlation between those that abuse animals and those that abuse humans, particularly the vulnerable like children and the elderly. Studies show close to 75% of violent animal abusers also go on to commit crimes such as rape, domestic abuse, and even homicide. This statistic indicates abusers have the propensity to escalate and to continue their criminal behavior, and with no deterrent or accountability, most will do so. In fact, 2/3 of all convicted violent animal abusers have also abused a human. This bill comes from the need to separate intentional torture and gross neglect from simply ignorant pet ownership skills. So the abuser will face the appropriate charges for their criminal act while assuring that all good pet owners, that their rights are protected in the process. And I think that we've done that in House Bill 258. And now I would like for Jeff to say a few words about this bill.
Good morning. Thank you, Chairman, for the opportunity to address the committee. And Representative Whitten has described the bill in detail. What I wanted to talk to you about is what does that look like in real life? And I can try to paint a picture for you. This is Ethan. Some of you may know Ethan, some of you may not. But let me tell you a little bit about his story. He looks very happy, healthy, chewing on his bone right now, but that's a far cry from how his life began. Ethan was sold as a Presa Canario puppy. He was soon traded for drugs, and thus began a 7 to 8 month, unbelievably hellish life he had to endure. Ethan was intentionally restrained in a kennel that was way too small for him to stand or even move around. Because of not being able to move, Ethan developed pressure sores on his legs. These are similar to bed sores. Ethan's sores were down to the bone, extremely painful, and he still has scars from them to this day. He was intentionally deprived of food and water. He suffered from a lack of food for so long that his body began to deteriorate. The loss of his internal body fat was followed by muscle loss and atrophy. His internal organs began to shut down. When you're starving, it's not the lack of food that kills you. It's the unbelievably extreme, painful deterioration of your body from the inside out. Ultimately, a dog or a cat will die from cardiac arrest. Combine that with the intentional dehydration. His mouth became dry, his lips became parched and cracked, his tongue swelled, his eyes receded, the lining of his nose cracked and bled, the lining of his stomach dried out and caused vomiting. Ethan was in such a state of dehydration. He weighed a mere 38 pounds when he should have been closer to 90, that his veins were so tiny that the only IV needle that would fit into his veins was the smallest needle made for a 1 to 2 pound kitten. To see him that day was devastating. Upon first glance, you would think he was not alive. He was unable to lift his head or move. In the words of his vet, Ethan was actively dying. The intentional starvation and dehydration would eventually lead to lesions forming in Ethan's brain that would result in seizures later in his life. He is currently on lifelong medication for seizures because of this intentional torture. And then there's the abuse that he endured. When conducting an MRI scan of his brain to determine the cause of the seizures, it was also noted that Ethan had blunt force trauma to his brain caused from being hit in the head. All of these constitute intentional torture with wanton disregard. Someone intentionally tortured and abused Ethan. This is a crime, and it needs to be a felony. Someone knew exactly what they were doing, and they just didn't care. And make no mistake, the person that abused Ethan is abusing somebody else right now to this day. It may be another dog, it may be another cat. More likely, it's a person, a child, a partner, a spouse. That's if they haven't already moved on to even more violent crimes against people that they don't even know. I have a ton of statistics I could share about the correlation between animal abuse and violent offenders, but you guys know all of them. Bottom line, a great way to stop violence, abuse, murder, rape, and mass murders in Kentucky is to find these people early on and punish them then. Make sure we can document the indicators that will eventually lead to more horrific crimes in our community. While HB 258 is a torture bill that will inevitably help dogs and cats in the Commonwealth, passing this important legislation will undoubtedly make Kentucky a safer place for our families. We know Ethan's name because he lived. There are so many Ethans out there that have suffered and did not live through their torture. We have the power to help them. Personally, my life has completely changed over the last 3 years. Seeing this intentional abuse firsthand, struggling to take a breath, eventually struggling to learn how to walk all over again, I believe in my heart that Ethan is alive for a reason, to bring awareness to these animals and some punishment to the criminals. I feel honored that he has chosen me to be the voice of his mission. Ethan had to endure every aspect and defining point of this bill. He's shown that even through intentional and neglect and abuse, love and kindness still win. His story and journey has brought so much goodwill, happiness, recognition, and support to the people of Kentucky. I'm a very positive person. I believe overwhelmingly percentage of people want to do the right thing and want others to do the right thing. And I believe in my heart that the right people are in the right place and the stars have aligned. And this year, that this important legislation will pass in Kentucky. Over the last 3 years, I've had the privilege to accompany Ethan to so many cool places, bringing awareness, smiles, and joy everywhere we go. But this one right here is right at the top of the list. To be able to sit in front of this committee, in front of you guys, trying to do our part to help animals is really pretty amazing. From dumped in a parking lot to in front of this committee trying to help. So thank you very much. I want to thank Representative Susan Tyler Witten, Representative Jason Nemus, Representative Chris Freeland, and a huge thank you for all of you for your time allowing me to talk today.
Motion on the bill.
Motion and a second. Thank you for your presentation. We're glad to have Ethan with us, and we obviously finally remember Senator Buford, who was an animal lover,
Yes.
served in the Senate with distinction for a long time. We miss Senator Buford.
Chairman, if I may say in closing, I will ask that this bill be called Ethan's Law.
Oh, wonderful.
In honor of this.
And I know a lot of us followed his story and the abuse that he endured. And I know there were a lot of questions about whether he would survive. But thank you for your coming today and appearing before the committee.
Thank you.
Representative Nemus, you're recognized.
Thank you, Mr. Chairman. I want to thank the gentleman and the lady at the table, but also note that I think, Representative Witten, I just wanted to point out that also has another bill on animal welfare to make sure that we are training. I don't remember the exact bill. It's to train animal control officers to identify abuse that might abuse children. And so
Yes.
this is the first step that we're trying to take to address these kinds of concerns. And so I want to thank you for bringing the bill there. So I just had that comment, Mr. Chairman. Thank you.
Does anyone else seek recognition? Representative Bradshaw, I thought.
I want to make this yes vote in favor of a dog named Arrow that was in Fairdale a few years ago that nobody knew the name of the dog. It was a beagle, but somebody shot an arrow into the dog. He lived for like a few hours before he died. And that's what really woke me up on these bills. And I appreciate Representative Witten bringing this and continuing this fight. You know, when people approached me on Arrow, I really knew nothing about the issues in Kentucky as far as animal abuse. But I found out that upon investigation that Kentucky was below 50 in animal abuse laws, meaning the territories of Guam and the Caribbeans were higher than Kentucky. We were like 53 out of 50 states. And that's not a mistake. It was really below all states. And we passed several laws since then. Senator Julie Rocky Adams and Whip Nemus here and many others in the legislature. And I was so happy when we moved up into the low 40s. But I think with bills like this and with the care that Representative Whitten is giving to this issue, that maybe we'll get into the mid 20s or something, or maybe one day be at the top. So thank you for this.
Thank you, Representative Bratcher.
He agrees.
Thank you, Ethan.
Ethan votes aye.
And I'm supportive as well. So I appreciate the comments. And I think this bill is narrowly tailored, and it does give our prosecutors the ability to charge these perpetrators in a way that will adequately punish them for these horrible acts. So if there's no further comments or questions, Mr. Secretary, please call the roll.
Representative Banta.
Yes.
Representative Blanton.
Pass.
Representative Bratcher.
Yes.
Representative Bray. Representative Burke.
Yes.
Representative Decker.
Yes.
Representative Dietz.
Yes.
Representative Doan. Representative Flannery.
I think, explain that yes vote.
Yes.
I'm going to vote yes today, but one thing that I believe we should be mindful of is that criminal abuse 3rd degree and assault 4th degree are misdemeanors. So when we start talking about people and children, I think we need to be more mindful that let's not put maybe the animals on a pedestal over humanity. I'm an animal lover, have several pets myself, consider them part of my family, but maybe let's not make all this a felony when abuse to people is still a misdemeanor. Thanks.
Representative Herron.
Yes.
Representative Kulkarni.
Yes.
Representative Lewis.
Yes.
Representative Maddox.
No.
Representative Mosher.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
I'd like to explain my vote, Mr. Chair.
Yes, go ahead.
I'm going to vote yes today, but I see some definitions here I think need to be expanded upon, and I'll get with you afterwards. Thank you.
Representative Stevenson.
Yes.
Representative Wilson. Yes. Chair Elliott.
Aye. So with 16 yes votes, 1 no vote, and 1 pass vote, House Bill 258 is amended by the committee substitute is passed and will be reported with favorable expression. Congratulations.
Thank you. Thank you, Chairman.
Thank you. House Bill 45 is the next item. Sponsor Representative John Hodgson, an act relating to privacy protection. You may proceed. You can introduce yourselves for the record.
Thank you, Mr. Chairman. John Hodgson, State Representative, District 36.
Representative John Blanton, District 92.
Representative Daniel Grossberg, District 30.
Okay, thank you, Mr. Chairman. If we look familiar, it's because we were here this summer for an extensive review of this bill. Since that time, we've been through an exhaustive process with a number of concerns, trying to make sure that we didn't have any unintended consequences with this bill. But essentially what it does is it provides privacy protections for the public from the rapidly evolving means of electronic surveillance and tracking. This is a bipartisan bill because nobody really likes to be spied on, tracked, or have their personal data stolen. So the following technology issues are addressed. First, unauthorized drone surveillance, either by private citizens or the government. Drones can't view or film anything that a person could not see standing in a lawful place at ground level. And there are exceptions, of course, to that, but it mirrors a Florida law that has been tested over time. Second, coercion of human microchip implantation. Believe it or not, tens of thousands of people in the world have consented to having a microchip inserted in their skin to use for identification, payment access, and that sort of thing. So we would make coercion to that illegal. Third, possibly most important in this election season, is the AI, artificial intelligence, AI deepfake dissemination. We can talk more about that, but deepfakes are something that is indistinguishable from an actual film of somebody doing something. So they can depict someone committing a crime, doing something embarrassing that could affect their life, their reputation, their financial prospects, their electoral prospects. Fourth, it has to do with license plate reader data. As we've seen license plate readers proliferate, that this information cannot be stored for over 30 days or sold, with some law enforcement exceptions and insurance crime exceptions. Lastly, the unauthorized use of micro tracking devices that are starting to get smaller and smaller. Drop one in somebody's pocket to track their whereabouts would be illegal. So these emerging surveillance technologies are already being used and misused around the world, with little defined legal protection for citizens. We have drones being used to spy on neighbors and people in their private fenced yards in Kentucky. We have AI deepfakes that have been used for slanderous and political purposes. We've already seen that this year and will likely be used to try to influence the 2024 elections. Private companies are seeking data from license plate reader cameras for their own purposes. It would include tracking over time the movements of American citizens. We don't think there's a negligible financial impact of this bill because it really doesn't cost anything to not spy on somebody. So gladly entertain your questions or comments from my
Motion on the bill?
There is.
Motion on the committee sub.
There's all in favor of the committee sub, please say aye.
Aye.
Those opposed, no. And the committee sub is adopted.
Motion on the bill.
There's a motion on the bill by Representative Nemus. Is there a second on the bill? Was that Representative Bratcher? There's a second. As amended by the sub. Representative Maddox has a question or comment.
Thank you, Mr. Chairman, and I'd like to thank the sponsors for their willingness to engage in a lengthy dialogue about this piece of legislation. There's a lot of good things in here. It's not a shocker to anybody that I would rather ban the automated license plate readers outright. I think they're an incredible violation of our privacy, and I understand that you're seeking to regulate that, therefore kind of enshrining it in statute. My question relates to page 9. In section 7 under B, where it says that introduction means subcutaneous injection. And I wanted to ask, does this apply to private employers?
Yes.
Thank you, sir. My follow-up question would be, would you be willing to entertain a floor amendment to the effect of also making it to where other types of mandatory injections are not allowed?
I think if they're for electronic surveillance, yes. And I think I sympathize with the nature of your question, and we've agreed on that in the past. But I think keeping this bill focused on curtailing electronic surveillance is the goal right now.
When we're talking about the subcutaneous injection of, on behalf of a private employer or any employer, the bodily autonomy of someone to say, I don't want that injected into my body. I do think that it is relevant, and it's a discussion that I would like to have in order to earn my support for this legislation. Not that you have to have it, but I do think that if we are willing to delve into the area of private employers, which this august body was previously unwilling to do with relation to mandatory immunizations, if we're doing it here, I think that we need to have that discussion. Thank you.
Thank you. Is there any other member seeking recognition? If not, Mr. Clerk, please call the roll.
Representative Banta,
Yes.
Representative Blanton,
Aye.
Representative Bratcher,
Yes.
Representative Bray, Representative Burke,
With compassion for our former colleague, Lamine Swan, I'm very honored to cast my yes vote.
Representative Decker,
Yes.
Representative Dietz.
Yes.
Representative Doan.
Yes.
Representative Flannery.
Aye.
Representative Herron.
Pass.
Representative Kulkarni.
Pass.
Representative Lewis.
Yes.
Representative Maddox.
Mr. Chairman, may I explain my vote, please?
Yes, you may.
I intend to vote yes today on this legislation with the hope and expectation that we can have an ongoing discussion on the basis of the floor amendment that I'm going to file to this legislation that would allow for that privacy and that ability for an individual to decide what substances, or in this case, devices, go into their body, whether it's a public employer or a private employer, because I respect the fact that you're trying to protect privacy here, but I think that that extends beyond the realm of just electronic devices. Thank you.
Representative Mosier.
Yes.
Representative Nemus.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Yes.
Representative Wilson.
Yes.
Chair Elliott.
Aye. Seventeen aye votes, no votes, and 2 pass votes. House Bill 45 is amended by the sub is favorably passed. So congratulations. Thank you.
Thank you, Mr. Chairman.
House Bill 47, an act relating to restoring religious liberty. Representative Steve Rawlings, the sponsor. I know you have some guests with you. I think probably what we'll do, Representative Rawlings, is give your side, the proponents, 20 minutes.
Okay.
And the opponents 20 minutes, just so that we're not going too lengthy on this. So we'll start a clock for you, and that would include discussion of the committee, that 20 minutes. So,
That sounds good, Mr.
and I'll
Chairman.
start the clock.
Thank you very
right now.
much.
Thank you.
All right, I'm Representative Steve Rawlings, and I serve the state's 66th House District. Mr. Chairman, we've got a committee substitute.
There is. Is there a motion there's a motion. Is there a second? There's a second. All those in favor, please say aye. Those opposed, no, and the committee sub is adopted.
And I'd like my guest to introduce himself as well.
My name
Please
is
go ahead.
Greg Chaplin. I'm legal counsel. My name is Greg Chaplin. I'm legal counsel with Alliance Defending Freedom.
Thank you.
The committee substitute just made one change to subsection 7, the last provision on page 2. It was sovereign and governmental and qualified immunity are waived, and qualified immunity was taken out. So that's the only change.
I'm sorry. I'm not. Are we good? Okay. I heard some commotion and I wasn't paying attention. So maybe that's a good thing. You may
Okay.
proceed.
All right, thank you. This measure seeks to update the Religious Freedom Restoration Act. They're commonly called RFRAs, and ensure that Kentuckians are free to live and work according to their faith without fear of being unjustly punished by their government. Our act is the shortest of any of the 25 states that have a Religious Freedom Act. At present, it does not contain definitions. Our present act is actually only 2 sentences now. That's all there is to it. The brevity of our current statute and the lack of definitions can give courts, and not the people elected to make laws, the excuse to undermine the religious freedom of Kentuckians. Definitions provided within HB 47 help to ensure that Kentuckians of faith can rely on the act to be heard in court. They can also give the courts clarity in how they should weigh these rights against the state's interest in burdening them. Kentucky's Religious Freedom Act is 11 years old. Since its enactment, courts across the nation and the U.S. Supreme Court have developed the meaning of terms found in similar laws on the books in other states. Some courts interpret their state's religious freedom language so narrowly that they refuse to hear certain religious claims. Other courts have taken more expansive approaches to these laws. HB 47 codifies definitions that are most protective of religious freedom, relying on what is working on other states and the result of court cases. Ultimately, this bill seeks to ensure that religious rights are adequately protected. HB 47 ensures that Kentucky courts will use the most accommodating language to ensure that religious Kentuckians have a fair day in court. Codifying these definitions will ensure that Kentuckians can be heard if any part of the government burdens their religious practices. HB 47 does not create new rights. Instead, it codifies the judicial standard that determines how seriously we take our commitment to religious freedom in this Commonwealth. Religious people and houses of worship are facing more and more government intrusion and violations of their right to freely live and worship. We need to ensure that our Commonwealth has the strongest Religious Freedom Act before these trends worsen. I move for adoption of House Bill 47, House Committee Substitute 1.
Motion by Representative Rawlings. Is there a second on the bill? There's a second by Representative Flannery. And we do have some discussion. I have a question. Representative Rawlings, I know you've heard a lot of the criticisms of this. You've been working on it a long time, actually passed through this committee last session. Very similar version as to what you're presenting here today. Do you have a concern that this could potentially open cities and local governments to a runaway train of litigation all of a sudden based upon someone suggesting that their religious freedoms have been burdened? Do you have that concern at all? And I know that's one of the concerns that members of this committee are getting from those who are opposed. But I just wanted to give you an opportunity to address that or
Thank you.
The council that's with you.
Well, I do not, because of the track record that RFRAs have across the nation. It's in 25 states. Many of the states have been under the law for 10 or 12 years, and you don't have the theoreticals that we've been hearing, the possibilities, the types of claims that are being brought up. That's not happened. So in that respect, I don't anticipate it based on the track record of the 25 states.
And I know specifically in 1B of the substitute, substantially burdened is defined, not limited to, but primarily defined as withholding benefits, assessing criminal, civil, or administrative penalties, or excluding from governmental programs or access to governmental facilities. So these are more than likely the predominant number of claims that would come from an individual would come on the basis of those three areas. Do you agree with that?
That's correct, yeah.
Representative Nemus.
Thank you, Mr. Chairman. I want to start off by saying I want to thank you for bringing this bill. I'm a supporter of it. But I also want to note that we've received a lot of communications from, or at least I have, from people in my district concerning fairness ordinances. I've heard from Chris Hartman and a number of other people, and I support our fairness ordinance and like fairness ordinance to go statewide. I want to talk about the reason that this bill I think is necessary, and then I want to ask you if you'll continue to work to see if we can improve it to make sure that we're not harming the appropriate enforcement of fairness ordinances across, or at least in the places that we have them. So my understanding is we've had a Religious Freedom Act in Kentucky for some time. In 2020, there was a case. I want to talk just briefly about this case because I think this was the catalyst to this bill coming, or at least it was the catalyst to my supporting it. It was Rupplinger versus Louisville Metro Government. And in this case, there was a woman who was arrested while protesting. She was a Muslim, a woman, and she was wearing a hijab during her arrest. She was asked to take her headscarf off, and she said she felt that was okay because the officers that were asking her to do that were women. Then she had to go and get a picture, a photo ID, and it was a male that gave her a photo ID, that was going to give her the photo ID, and he asked her to take it off again, and she felt that was a violation of her religious freedom, that in her religion, she's not allowed to take her headscarf off around men who are not in her family. They made her take it off, they took a picture, and then they published the picture for the public. And so she sued, and I think she should have recovered. It doesn't seem like there's a compelling government interest to make her take off her hijab. And if you're going to do that, then it's easy to accommodate and make it women officers only. And why would it need to be published in that way where she doesn't have her headscarf on? That was her religious beliefs. So she filed a lawsuit, and the court in Rupplinger said that she couldn't recover. And I think that was wrong. And so that's the catalyst to this statute.
Yeah.
And so while I think we're trying to get at an important thing, that Muslim woman should have been able to recover, in my view. Okay, fast forward to today, where we have a lot of people who are worried that it's going to go too far and infringe on their rights. So I don't know where the right, where equilibrium is, where we can satisfy both interests and protect this Muslim woman and people of her like her,
Right.
and also not go too far and effectively obliterate fairness ordinances. So my question for you is, one, do you have the right balance? But number two, will you commit to continue to work with people who are here, and I'm assuming we're going to testify in a moment, to limit this bill for the proper protections to ensure that it doesn't go too far?
Yes.
Is that something you're willing to do?
Yes, I will commit to that, to helping people that are here and not making sure that the claims don't target them, don't come after them. And I'd like Attorney Chafin to testify as to this and talk a little bit about the compelling government interest.
Certainly. And Mr. Chairman, Representative Nemes, thank you for that question. I think that highlights one reason for this bill being brought forward, but also dovetails with the other thing that you mentioned. So that's the topic of sovereign governmental immunity. And you're right. In that case, there was a certified question to the Kentucky Supreme Court asking if the Religious Freedom Restoration Act that you currently have and have had for 10 years, that's worked pretty well for 10 years. They asked, does this waive sovereign governmental immunity from suit so that she could have pursued remedies? And there, the Supreme Court here said, no, it doesn't waive sovereign immunity. And that means there are certain remedies that are just unavailable to people of, in this instance, minority religions. And so they said, you need to explicitly make that clear. And they cited to, in that case, they cited to the Civil Rights Act that you have here that does give a cause of action that makes it clear that you can seek those kinds of remedies. And so, you've had it for 10 years. This sets religious freedom and answers the question, what do you do when a state law is imposed in a way that stops someone from exercising their religion? What is the right balance for the state's interest in enforcing its laws and your citizens' right to exercise their religion? You're exactly right. What is the balance? And this is the test that used to be used at the First Amendment level. 30 years ago, the Supreme Court changed that. That's why unanimous Congress made this rule. This is the balancing test. It doesn't pick winners and losers. Everybody can bring their fair day in court, and the courts will judge what is the religious interest involved here. And then if they can show a burden on a sincerely held religious practice, then it goes to the government side to say, do you have a compelling governmental interest to enforce that law? In these fairness situations, there may arise a situation where it raises to that level. And then you ask, is this the least restrictive means? Is there any way you can accommodate a religious practice in this state? And so it's the proper balancing test that courts can apply to every case, does not pick winners and losers. And that's why with all of the hypothetical situations that you may hear about, those, we haven't seen a parade of horribles of things not working. We have 30 years of it working, and now 25 states use it and use it well to strike the right balance between our first freedoms of religious freedom and the state's interest in imposing other laws. So it's not going to decide any particular outcome. Every case is very fact specific. It just gives people a fair day to bring their case to a court for the courts to assess the facts in each situation to balance those two interests.
Thank you, Mr. Chairman. I'll have questions for the other side as well.
Representative Banta.
Hi, thank you for this bill. I'm still trying to wrap my head around how this is different than what we already have. But you heard right before you, we had an animal torture bill. So what if we have a religious group that sacrifices animals? I'm trying to figure out how this balances. I mean, does that mean our court has to hear that and they decide that's a valid religion, and so that, we can, I don't know, sacrifice animals?
So Representative Banta, thank you for the question. So I think the previous bill, I'm not intimately familiar with that bill, but I think it has to do with intent and certain levels of intent in harming animals in a torturous way. There are examples in California of Jewish people who need to sacrifice chickens for a religious ritual. Would you stop the Jewish people from being able to sacrifice chickens for their religious ritual here? Again, doesn't determine the outcome, but if there is a law that would stop them from doing that typical Jewish tradition, it would go to a court then to decide what is the religious exercise, is there a compelling governmental interest, and is this the least restrictive means or not to allow them. So again, it can't determine the outcome, but at least would give them a fair day in court to say that that traditional practice of chicken slaughter, if that bill, I don't know, but if that bill would stop the Jewish community from doing that, this bill would very importantly give them a day in court to say, okay, that bill can survive, but we have this long-standing tradition that needs to be respected, if it can be respected.
Thank you.
Representative Kulkarni.
Thank you, Mr. Chairman. I'd like to understand specifically from the sponsor or, and I'm not remembering your name, sir, I apologize, the gentleman from Alliance Defending Freedom, I think. What is the specific impetus behind bringing this bill? And the reason I ask that is because in my view, we have constitutional protections both on a state and federal level. We also have the RFRA that we have adopted. So what exactly are we failing to accomplish in terms of a person being able to freely exercise today?
Well, an example that I could use is the Sunrise Children's Center from a couple of years back. The governor had refused to, well, he had stopped the funding and they were doing such good work, but he just decided that he didn't want to fund them based on their religious beliefs. So it's examples like that. When the governor made an independent decision on his own, they need to have a remedy to bring that action to a court action if they so choose.
Brief follow-up, Mr. Chair.
Yes, you may.
And I am not necessarily familiar, or maybe folks in the public may not be necessarily familiar. Was that solely based on their religious beliefs? I'm not.
That's my understanding, and that was the reason given. And later on, he relented and allowed the funding when there was a lot of pushback.
Okay, I'm sure there's a lot of other details that we're not going to have time to get into
Yeah.
here. I share a lot of my colleagues' concerns about striking the right balance and frankly, need to understand a little bit more about why this bill is even needed. Thank you.
Thank you, Representative Moser.
Thank you, Mr. Chairman. Thank you for bringing this bill and for this conversation. I understand the general idea of this. And you and I have talked a little bit about my concerns. I have a concern that this would potentially undo one of the bills that we passed in 2020, Senate Bill 72, which outlawed female genital mutilation. And I mean, that's, as I understand it, it's a religious practice in some areas. And so we outlawed it. We also have laws against child abuse and domestic violence protections. Will this in any way undermine what we have done to, sought to protect against really child abuse and domestic violence?
I can take this. It would in no way undermine child abuse laws or that female genital mutilation laws. The reason being because for 30 years, we already have on the books in many states, child abuse, neglect is not something that counts as a religious practice that doesn't meet this compelling governmental interest and least restrictive means test. You've had it here for 10 years. The female genital mutilation bill has not, been sent because of your current RFRA that you've already had. Child abuse laws also get to stand. So no, it would in no way undermine that. And to thoughts about, adding language that would specify that, I would just caution that, the principle, as I've been explaining, the principle lasts for any case, any factual scenario. If you start adding in particular carve-outs, there's a long list of things that would have to go into that list to make it complete, most of the criminal code. And then if you add just one thing but not others, you would be wary of courts inferring into that addition of one thing and not another that perhaps the legislature intended to exclude those others because they weren't included in the list. So there's no concern that it would undermine that or child abuse laws by any means.
Okay, I understand, I think. Mr. Chair, if I may just.
You may. There's 3 minutes remaining. We have three
Okay.
more questioners, so you can follow up and then we'll close the questioning off.
Yeah,
with the next
quickly, I'm just trying to understand the committee sub. It looks like it changed in subsection 4, except as provided in subsection 4 of the section. It just added that. And so what are we doing? Are we, can you just explain what we're doing there?
So Representative Moser, thank you for the question. My understanding is that in section 4, the one part that puts a caveat is it allows future acts of the legislature to exempt application of this law to it. And so that would be the situation in which there's a future law that is exempted from this. This is saying that you can still do that in the future.
Okay. All right. Thank you.
Thank you. Representative Herron.
Thank you, Mr. Chair. I did have a couple of questions, but folks have asked those questions, but I did want to follow up with you, Representative Rollins.
Yes.
You mentioned the situation with Sunrise Services.
Mm-hmm.
Just for the record, what I want folks to know is the issue with Sunrise Services is that they did not want to place children with same-sex couples. So that was a discriminatory situation. So me as a legislator who is doing a lot for our Commonwealth, that if I wanted to go through Sunrise Services to help our young people in the state, they would have the right to discriminate and tell me no, that they would not place a child with me. That's the intention of, from my understanding of what you just said, that is the intention of the reason why you brought this bill forward.
That is not the reason I brought the bill forward. My intention was to protect people of faith to be able to practice their religious beliefs. So that example is, I'm sorry that you feel that way about it, but we're looking at a broader protection of religious rights for people across the Commonwealth, that they can practice their religion according to what they believe. You want to add to that? Yeah.
I would echo that, but also just say, so the Supreme Court had a similar case arising out of Philadelphia, where the city tried to cut out the Catholic social services from providing services to hundreds of kids. They've been doing it for more than 100 years because of their religious policies. And these are organizations that are looking to serve people. And the idea is more options provides more services to more families, to recruit foster families. There are many options. Everybody can find a provider here in the state. But if the state's trying to shut down a particular organization because its beliefs don't align with what the state wants, that's where you start to get these issues of religious freedom means something. And what does this balancing test do? It gives the courts an ability to say, okay, what is the state's interest in stopping certain folks from exercising their religion? So in that certain situation, the idea is more options gives more providers more ability to find foster parents for the kids in the state.
Just Chairman, as a follow-up, I would like to say I do believe that I'm a Christian, grew up in a church, in the AME church actually, and so I do have a strong Christian faith and background. However, I do think that we have to be very careful when we say that based on your religious belief that you're allowed to discriminate against people. That is not what we need to be doing here in this Commonwealth, nor across the nation. And basically, this is what this bill says. And so I will definitely be a no on this, and I encourage my colleagues to do the same. Thank you.
So we're a little over 20 minutes. A little over 20 minutes, but I am going to recognize Representative Stevenson for comment or question, and then I'll recognize Representative Burke. And then that will conclude the proponent side. We'll go to the opponents.
Thank you, Mr. Chairman. I have some questions. I think the council said it earlier that this bill will allow people to go into court and have the court decide whether or not it's a bigger infringement or whether it's justified.
Sorry, so what the courts would do with this test, it's the standard. So Bill Clinton signed this and he's put it really well. This is the standard that courts will use when determining if the state can invalidate a person's religious exercise.
So when they do, so can't they go into court now?
Representative Stevenson, you're correct that you have a RFRA in this state and they can go. But as was said earlier with Representative Nimi's, so sovereign immunity is not waived. So there are a lot of remedies unavailable for the Muslim woman in that case and for other folks that would bring a claim under RFRA. As was said in the introduction, that this clarifies what the bill does with the definitions, relying on what other states have done.
Okay. And then in your definitions, it says any administrative organization of the Commonwealth, and it includes political subdivisions. Does that include the block captain down the street from me that likes doing particular things that I find offensive? Like there are some people that have a religion that will do things like you have to have sex with a virgin. You have to do particular things, and they call it a religion, just like Manson did, Jim Jones did. who is the arbitrator of what is a religion, and why are we now trying to give anybody the power to claim a religion to do bad?
Claim religion to do bad.
Well, it's not power that this bill seeks at all. It's protections, and it's not about discrimination either. It's about respect of all. We need to be respecter of all persons.
So my last question, Mr. So
You're cutting into Representative Burke's time, so.
Okay, it'll be quick.
I think you both want to speak, so go ahead.
I want to be sure that I understand that if I, in my neighborhood, I have the religion of the Klan coming down the street, that if I take action as a state rep under the color of the government, then I have a problem?
I don't agree with your premise.
Okay.
Representative Burke.
Thank you, Mr. Chair. My question is honestly kind of along the same lines as Rep. Stevenson. What is the current case law in Kentucky relating to who or what entities can be prevented from substantially burdening someone else's religious freedom? So who would be the respondents in a civil action is the case, my question.
Yeah, Representative Burke. So right now, you just have this typical language of a government. And so that would be whatever qualifies as government. And as was said in the introduction, that leaves it open to the courts to interpret how broadly or narrowly. As for Representative Stevenson's definition of religion, there's no definition of religion. It could be added a definition of religion. Many states do that. It's something for the courts. Again, it has to be a sincerely held religious belief. We have hundreds of years of case law talking about what is religion, what isn't it. It does need to be clarified. And then even if somebody gets to that point of being able to define what a religion is in a scenario where they're doing something, say, novel or unfortunate and bad, then you have to get to the next step of, is there a compelling governmental interest? And if there's abuse, violence, anything like that, there's a compelling governmental interest to stop that kind of violence. So that's why RFRA has worked for 30 years in states across the country to not allow those kinds of abusive things that you may be thinking of. As far as, who's covered, I think that's part of the reason the definition is necessary, because the idea of RFRA's answer the question, what does it mean to have religious freedom protection? And it means that if there's a state authority, if the power of the state is going to stop citizens from exercising their religion, then what's the appropriate balance? How do we protect religious freedom rights when the state is interfering in your personal religious beliefs? Not imposing on others, but in your living out of your personal religious beliefs. And so if the definition of government were narrowly tailored to just acts of the legislature, something like that, you may leave out people who are acting under color of state law or using the force of the government to impose. So if a private business were to have its own private policy about what to do in the company, that's the private company's policy, and RFRA cannot apply to that situation. But if there was a business that was forced by the force of the government to do a particular thing, like say, no hijabs can be worn in this Walmart, then you could have a person saying, if the government's forcing a private entity to force another person to violate their religious freedom rights, then the state's deputizing a private entity to go after someone else's religious practice. And so again, doesn't determine the outcome, but it will at least allow the employee to have a day in court to say, the state should not be forcing another private entity to be violating my religious freedom rights.
I think, I appreciate your answer, but I do think that Section 1A, Parts 2 and 3, which expands the definition of government to include any person acting under color of state law, which would be any of us who are attempting to follow laws, so everyone would be included, or someone suing under or attempting to enforce a law. This broad expansion to me is concerning because not every person who is a law-abiding citizen attempting to follow the laws should be hailed into court as a respondent. If they're following the law and the issue is the law, then the Commonwealth ought to be the respondent. And that's why I do agree with the section where sovereign and governmental immunity are waived. But I just can't see beyond the fact that we're really saying that everyone is now liable. So for me, that's too big of a problem. It will need to be changed.
So your time has concluded. Thank you.
Thank you.
And now
Mr.
we will
Chairman.
move to the opponents. And we'll do 20 minutes with some stoppage time. And I'm not a soccer fan. I think that's a term in soccer. The first person who is on my list is Chris Hartman with the Fairness Campaign. And we have quite a lengthy list here, so probably 2 to 3 minutes per speaker would probably work unless somebody wants to take more time.
Mr. Chairman.
So I'll
thank
start your
you.
time now. Thank you, sir.
So now I'm on. Chair Elliott, thank you. Vice Chair Decker, thank you for your time. Committee members, my name is Chris Hartman. I use he, him pronouns. I'm Executive Director of the Fairness Campaign. And because you will not have time to hear from all of them, we represent more than 100 Kentuckians who are in the room today, here and in the overflow room, who oppose House Bill 47. So I just want you to be aware how many folks are behind us, both figuratively and literally, to oppose House Bill 47. You know, we all believe that freedom of religion is essential in Kentucky and the United States. That includes the Fairness Campaign. And to that end, the freedom of religion is already strongly protected constitutionally, federally, and by state laws like the Religious Freedom Restoration Act. In fact, Kentucky's got one of the strongest Religious Freedom Restoration Acts in the country, which has already been referenced, was passed just about 10 years ago by the General Assembly here. And so we've already heard the questions. What is it that's not currently working about the Religious Freedom Restoration Act? What makes it so necessary to expand this? And I posit that the reality is that House Bill 47 is nothing but a jackpot justice law for the Alliance Defending Freedom, who actually came here today to not say exactly that, but to imply it. The Alliance Defending Freedom is a national interest group that seeks to fleece Kentucky out of millions of tax dollars while weakening civil rights laws by traipsing about our state to sue every city and county that has a fairness ordinance. They're already doing it. They're already using the existing Religious Freedom Restoration Act. But House Bill 47 will let them really cash in on our tax dollars to subvert the civil rights protections that we started passing a quarter of a century ago. The first fairness ordinances to protect LGBTQ people in Louisville, Lexington, originally Henderson and Covington. Now there are 24 communities all across our Commonwealth that have stood up to protect LGBTQ people, and you're putting every one of them at risk if you pass House Bill 47. I'll also draw your attention, which Representative Burke was already referencing, that House Bill 47's definitions are so broad that it will allow private individuals to sue one another over violations of religious freedom. It puts all state and local laws, administrative regulations, and ordinances at someone's whim to subvert if they make a religious freedom claim. They could violate domestic violence laws, property laws, trespass laws, contract laws, civil rights laws. It's endless. I want to let you know that the majority of Kentucky voters oppose House Bill 47. We polled them less than a month ago on this bill. I've included that in the packets that I sent to your email addresses last night. And the reason that they oppose it is because of the endless uses and abuses that House Bill 47 will open up. I just want to give you just a couple of examples. Imagine that you are a property owner who enforces no trespassing on your property, but someone makes a religious claim, a sacred right to hunt on your property. You are going to have to go into court to defend trespass laws, and you are going to have to defend the trespass laws to pass the burden of strict scrutiny, not the government. That's your responsibility at this point, to keep someone off of your property. An employer sued by a black employee for racial discrimination, or a business owner sued by a customer for denying service to Jewish patrons, for instance, could assert a religious exemption to the state non-discrimination law. I've included several more examples in your emails. Again, the list is potentially endless. The rule of law is important. We shouldn't create sweeping religious exemptions that encourage people to pick and choose which laws they're going to follow or to file lawsuits over anything that they don't agree with at taxpayers' expense. Please say no to jackpot justice and vote no on House Bill 47. Thank you.
Thank you, Mr. Hartman. Kent Gilbert, Council of Churches. Please come forward. You're recognized.
Thank you, Mr. Chair. Thank you, members of the committee. My name is Kent Gilbert. I'm a part of the Kentucky Council of Churches. I serve on the Justice and Advocacy Commission. The Kentucky Council of Churches is 12 different denominational bodies in the state, represented across 16 different regional bodies. That includes Roman Catholic, American African Episcopal churches. We have Baptists. We have the entire range, rural and urban. Never once were any of our member bodies consulted about this legislation. And I can also report to you that never once in the council that meets regularly to discuss matters precisely related to religious freedom have we seen an urgent need for this. The Kentucky Council of Churches has been studying policy in the Commonwealth since 1947 and continues to be an active and avid voice for clear and responsible religious expression. We care a great deal about religious freedom, a great deal. However, this bill is not helpful. We feel that it confuses, that it broadens definitions, as you've just heard, and it also makes possible the kind of discrimination that persons of integrity of every faith tradition abhor. It certainly is not the case that the government should be permitted to specialize or specially favor a particular religious viewpoint over another. That does not help any of the other religious traditions. The bishops, conference ministers, and other regional leaders are united with me in saying this to you. Plurality is a virtue and a value. If we give ourselves the ability to sue one another over how we're currently being offended, if we give private, certain individual religious groups the ability to sue the government because they didn't receive the special treatment they felt they were required of, we weaken the protection for all. If we receive public money, we in the Kentucky Council of Churches believe that we ought to serve the public according to the entire laws equally and without prejudice. If you wish to serve under religious viewpoints, some specialized aspect of your religious faith, excellent, do so, but do not expect to snuggle up to the public trough in order to do so. That money was meant to the benefit of all. Now, most of our churches, almost all of them, support things like public schools, private schools. They have their own individual practices, none of which are burdened by this. This bill is not currently needed, in our opinion. We have strong protections under the current RFRA. We have the ability to bring redress, should it be needed. And it does not permit simple offense to become actionable under the law. Being offended should not be, and is not an actionable offense in a civil society. And freedom from offense or contrary opinion, even religious opinion, is not a right in a functional democracy. It's okay for us to differ. It is not okay, however, to bring frivolous lawsuits, to confuse government, and to burden, in fact, the well-being of all for the advancement of some. The council remains very open to sponsors of this bill to have some discussion with actual leaders, if that would be of help to you. We certainly, as I say, have more than 75 years of experience in legislative policy in this regard. It's pretty clear that the people who did this have very little legislative understanding of what they're doing. We'd love to help. We have an understanding and we have the access to those folks. Thank you for your time.
Thank you. I understand that.
Is there more
there's
speakers?
support, but let's not have applause.
Are there more speakers?
There are, but I'll recognize
Okay.
you for comment.
Well, I have a question to the last speaker.
Okay. Come back up with a question.
Thank you. And thank you for coming. I appreciate your remarks. I don't share the view that this isn't needed. It could go too far. I don't share the view that citizen can sue a person acting under color of state law. Lawyers should know that does not mean citizen A and citizen B. That means like police officer. And so when I read every Supreme Court opinion as they come down, And when I read Rupplinger in 2020, I thought to myself, that's not right. I think you would join me in saying,
I would agree with that.
She needs a recovery, though. So she needs a recovery. And in my view, speaking for myself, the fairness ordinance needs to be protected as well. So there has to be a way to get both places. But to say this isn't necessary, that's not fair to Ms. Rupplinger.
I'm not sure that I would agree with that, though I appreciate your comment, and I think there's lots of room for conversation. I think that it's possible for a decision on an existing statute to be in error without having to say that the law itself was in error.
Well, the whole decision said that she couldn't recover. That was the whole decision.
And perhaps
you disagree with that, and so do I.
Well, that's right.
Okay.
And I think there is room to say this bill, however, does not address my concern that it does so in that balance that you spoke of. I agree with you that
I've got a commitment from the sponsor. Everyone in this room listen to it. That he is going to look. He's going to sit down and he's going to work on this to properly tighten the definitions and so forth and so on. But
we look forward to seeing.
But the reason that I'm for this bill, and I'm a co-sponsor, proudly so, is not to violate fairness ordinances. I'm not for that. I want them to go statewide. But Ms. Rupplinger was mistreated. And she needs a recovery. And
but we want Senator Representative Nemes. I really appreciate your comments, and this is exactly the kind of conversation that would be perfect to have before this legislation was proposed.
We've got time.
Yeah. Okay. If we do, I'd be honored to
I
be a part
haven't
of
read the case that you're referencing, Representative Nemes, but was the basis of the denial sovereign immunity?
That's right. That the basis of the denial was sovereign immunity, that she couldn't recover. And I'll send this out to all
she
members.
Couldn't even really present her claim based upon
That's right. And with the understanding that we've got a commitment from the sponsor to try to tighten some of this language, I think we need to move forward with it. Thank you, Mr. Chairman.
Thank you, sir. Dr. Bonnie Meyer, if please come forward and you're recognized. And we are, let me check my clock. We are at 11 minutes and 30 seconds. So
All right.
you may proceed.
I have notes, so keep me in line. Bonnie Meyer, Dr. Bonnie Meyer, thank you for the opportunity to talk with you all today. Can you hear me okay? My name is Dr. Bonnie Meyer. I'm here today as an educator with over 20 years of experience. I currently teach people who are going to be teachers and have a pretty good pulse on some of the things they're concerned about and many conversations that I'm hearing today. I'm the president of the Northern Kentucky Pride Center. I'm a proud Northern Kentuckian. I'm a resident of Covington. And I think specifically to Representative Rollins and to our Northern Kentucky caucus, I can assure you that House Bill 47 does not align with the values of Northern Kentucky. Half of the fairness ordinances in the Commonwealth are in Northern Kentucky. We've been doing really good work up there for 20 years plus. I'm really concerned about the message that this sends. We already have the legislation in place. I'm navigating this. I've navigated this for 13 years in Northern Kentucky. And I think a lot about what our college students and what our talent and what our youth think when we have elected officials who are making these sorts of decisions about their lives. Having worked with college students for most of my career, it seems at times as if the intent of this legislature is to run all of the talent out of the Commonwealth of Kentucky. The world is changing, and our youth, our students, our college students, and our young professionals demand and expect to live in places that value diversity and inclusion, whether they're part of the LGBTQ community or not. We expect fair cities. They expect fair cities, and so do I. I've watched for the last couple of years as this platform has been used to attack our youth, to attack our LGBTQ families.
Let's restrain our comments to the bill before you. You may want to.
And I certainly would say.
You may want to go into a history
yes,
of what we've done here, in your opinion, and you're entitled to that. But I want your comments on this bill.
And my comments on this bill is we're stripping away the rights of LGBTQA folks. Certainly, when we look for cities, I work with college students who look for cities so we can keep them in Kentucky, so we don't lose them across the river. We want to keep them in Kentucky. When you are saying that things like fairness don't matter, which is that's the message that this sends. It sends the message to those of us in Northern Kentucky who've done a whole lot of work to say fairness does matter. It tells us that you don't care. It tells us that what we do, who we are, the lives that we live don't matter. So respectfully, I think I'm speaking absolutely directly to what House Bill 47 very feasibly will do to our community, to our lives, to our families, to our livelihoods, should you move forward.
with this piece of legislation. I'm certainly happy to talk, especially to the Northern Kentucky folks, if you'd like to. Like I said, I live in Covington. I have 13 years of experience working specifically on LGBTQA issues throughout Northern Kentucky, schools, corporations, business. I'd love to talk with you. I ask that you please vote no, and that we do stand up and support all Kentuckians, all Kentuckians. Thank you.
Thank you. 15 minutes have elapsed. Erica Fields, if you're here, you may come forward. Thank you. Please introduce yourselves and then you can proceed.
I'll go first. My name is Erica Fields, and good morning, and thank you for having me here. I am the president of Civitas Regional LGBT Chamber of Commerce, located in Louisville, but we represent members throughout the state, everywhere from Richmond and Lexington up to Covington and areas in northern Kentucky as well. We have about 53 members, but we are an affiliate of the National LGBT Chamber, which is the NGLCC, and they have 53 affiliates around the country. We represent LGBT businesses throughout the nation, and here in the Commonwealth, there are 20 certified businesses as well as 53 other members of our organization. The LGBT's business community's impact on business and on the economy nationally, 1.4 million LGBT businesses with a combined economic impact of $1.7 trillion would be the 10th largest country by GDP. LGBT-owned businesses can be found in every industry segment, and that's true here in the Commonwealth as well, from construction and related services to technology and cybersecurity to aerospace and defense, advertising and agriculture. In fact, I am also a businesswoman. I own a business called Brooks Grain. We supply grain to the urban industry, and we're very involved in the agricultural community within Kentucky. The number of businesses that are supportive of the NGLCC are 438 of the Fortune 500. They include local companies like Yum, Humana, GE Appliances, Kindred Healthcare, and UPS. There's also regional representation: Kroger, Anthem, Caesars of Southern Indiana, Diageo, Beam, Brown-Forman, and many of the other companies you're all familiar with. The concern that I hear from these companies about a bill like this that would pass is not so much the actual details of the bill, but the fear and the perception of what it will cause when they have to go out and try and draw employees into the state. And I know this personally because I moved my business here from Minnesota in 2017. I've been doing business in Kentucky for almost 50 years. And when I moved here, pretty much everyone I knew was concerned about me moving to a state like Kentucky from a state like Minnesota. And I assured them, because of the assurances I got from my customer base, that Kentucky was very open. They had fairness ordinances in many of the cities. I got to know Chris Hartman. I got to know other people within the community here, and I felt very comfortable moving my company here in 2017. I know that if this bill were to pass and I were to look at it in the future, or I were to be asked by someone in the future, I would say, you might want to think about it a little bit, because you just don't really know how far these things can go. Now, I have heard from the proponents that they're very certain that there wouldn't be any frivolous lawsuits or anything like that brought, but we never know. And it isn't a matter of whether or not that is going to happen. It's the perception of an executive being searched by Yum Brands to come to Louisville. His perception as a member of the LGBT community and having his family move here, what would that really do, or what is the risk, and where else can I move, and what other opportunities are there? So it really does have economic impact in Kentucky. So with that, I'm going to pass the mic over to my colleague here.
Hi.
You're recognized. Thank you.
Thank you. Lyles Taylor, I'm a magistrate in Woodford County and representing local ordinances for non-discrimination passed. We're the only county outside Jefferson, Fayette County that have a countywide fairness ordinance, but I'm proud to say that that came into fruition, a real interlocal government cooperation. The cities of Versailles and Midway passed preceding us similar ordinances, and my concern is that this bill, House Bill 47, could put that at risk. And these local non-discrimination ordinances are a symbol for businesses and individuals and families that we're a welcoming community that goes further than just protecting these individuals from discrimination based on who they love or how they identify. They ensure that members of society have an equal access to employment, housing, and public accommodations. And in times of workforce shortages that we've heard a lot this session about, these kinds of ordinances demonstrate that our county is open for business and encourages segments of the population to work in our community when they might avoid communities where they feel vulnerable to discrimination otherwise. House Bill 47 may be a threat to and ideologically incongruent with local control. We were, the third municipality in the county to pass such an ordinance, and we held 2 public hearings on it with multiple stages for feedback through our committee process, as well as our 2 required readings. I held discussions with local ministers about their concerns and, in fact, included language at their request explicitly about frivolous lawsuits, and I think that might be something that could be considered for relevant language that would maybe amend House Bill 47 to be less impactful to these issues. But again, not only that inclusion of that language, particularly citing the state RFRA language, should put those concerns to ease, but also that's what makes House Bill 47 less necessary or unnecessary in other cases. And again, it only leaves the county government potentially subject to frivolous lawsuits bankrolled by out-of-state organizations looking for a payday. Thank you.
If I get my microphone on, the time has expired. Thank you for your testimony. I don't think any of us here want to open a floodgate of lawsuits or, for that matter, to invalidate what local cities have done across Kentucky. I don't think any of us are here to do that. So I agree with Representative Nemes that we can look at ways to prevent that, then that's what we need to do. And I'll be supportive of that effort. We have had a motion. We've had a second. And would our clerk please call the roll?
Representative Vanta.
No.
Representative Blanton.
Aye.
Representative Bratcher.
Yes.
Representative Bray.
Yes.
Representative Burke.
No.
Representative Decker.
Yes.
Representative Dietz.
I'd like to explain my vote.
Yes, you may.
I'm going to be a no today. I understand the intent, I believe, of Representative Rawlings and what his intent is. And I agree with Representative Nemes that we may need to tighten up some definitions. So my vote on the floor may change, but for today, I'm a no.
Representative Down.
Yes.
Representative Flannery.
Aye.
Representative Herron.
No.
Representative Kulkarni.
Briefly explain, Chairman.
Yes, you may.
I'm going to be a no for today, and I understand that there's been a lot of discussion about the balance, and I'm glad that the sponsor is committed to further discussion and possible amendment to this legislation. My concern here is that the reality in Kentucky is that we live in a very litigious society. We live in a society where discrimination exists, and the legislation that we're voting on in committee today is overbroad, it's unnecessary, and in my opinion, and hopefully we can fix this, but would open the gates to bad actors, discriminatory actors, and weaken the protections that we have for some of our most vulnerable Kentuckians. The freedom to exercise religion does not mean the freedom to discriminate, and I'm hopeful that if this bill passes committee, that we are able to amend it so that it does not have the unintended consequences as discussed by the sponsor himself, and that we can create some legislation that is not going to harm Kentuckians any further. Thank you.
Representative Lewis.
I believe the bill needs to be tightened, but I'm a yes for today. Thank you.
Representative Maddox.
Yes.
Representative Mosier.
I'd like to explain my vote.
Yes, you may.
I don't want to interfere with any fairness ordinances. I don't want to increase litigation. I think that this feels pretty broad. I will be a yes today simply to move this to a point where we can work together with the assurance that we will make some changes to narrowly focus this language. I have concerns, but I'm willing to work with you. Thank you.
Representative Nemes.
Yes.
Representative Petrie. Representative Rawlings.
Yes.
Representative Sharp.
Aye.
Representative Stevenson.
Explain my vote, please.
Yes, you may.
I find it hard to believe that we didn't consult the people that are experts in this area. We did consult the communities. But if we pass this bill, then we'll consult them. No.
Representative Wilson.
I'd like to explain my vote.
Yes, you may.
I'll be a yes today, but I share some of the same concerns as Representative Nemes, Representative Mosier. Not guarantee a yes on the floor, but I will be a yes today. Thank you.
Chair Elliott.
Thank you, and I'm an aye vote for the reasons I talked about earlier. So with 14 yes votes, 6 no votes, and no pass votes, House Bill 47 as amended by the substitute is passed. Should be reported with favorable expression. Is there any member who wishes to record a vote? I wasn't sure if anyone came in late. Yes, Representative Dillon.
Mr. Chairman, I believe I need to, I'm going to record a pass vote on 258. I'm going to record a pass vote on 320 and a yes vote on 436.
Okay, those are recorded. Anyone else seeking recognition? We did not. I'm sorry, we did not hear. We didn't hear my bill, so yeah, thank you. If there's no further business to come before the committee, we'll stand adjourned.
Okay. Actually, we're still next week. Yeah.